Be seated in court, please. All right, let the record reflect we're outside the presence of the jury. The witness has completed the testimony. Where are we at on motions?
Yes, Your Honor. After considering the testimony of the witness, we are asking the court to avail us, the defense, of the remedy of instructing the jury that they cannot consider her testimony at all for any purpose in its entirety. The failure to turn over the specific that specific piece of critical evidence has put us to a disadvantage with this witness, has put us to a disadvantage with our theory, as I've kind of outlined to the court in the ex parte brief that I provided. And we do not believe that, again, the court has denied the mistrial, but we do not believe that that allowing the jury to consider her testimony for any purpose, we believe that it'll affect the due process rights of the defendant and our ability to continue in the defense of the case in the way that we had set it up and prepared for in the first place.
State.
Yes, Your Honor. The accusation yesterday was significant. It gave us significant pause. The three very important things were left out. Number one, the shots flaring up around her. Number two, where the shooter was. And number three, the clothing that he was wearing. That gave us significant pause. But lo and behold, yesterday we were able to find out they did actually have the information about the shots being fired up and behind her. The evidence has been developed today that they did actually have the evidence that she said that the shots, I agree, not the gunman, but the shots came from the building and then indicated. So they do have information that she was aware of where the shots were coming from. That does leave, though, Your Honor, still that disturbing point about the clothing not being turned over. We agree that is improper. We should have done it because it was new information. Didn't seem all that significant since we had photographs of the shooter in black. But nonetheless, we believe, number one, it has all been cured through cross-examination. He has pointed out that she didn't say it originally. The jury is aware of the truthful nature of her conduct all the way, and they weren't ready and prepared to do that. It has not caught them off guard as of now because of the court granting a continuance. Second of all, Your Honor, we believe that if the court does believe some kind of measure is appropriate, we ask the court not to throw the baby out with the bathwater, and that is the only surprise that they're addressing is the black hair and the gun, and it would be appropriate if the court feels like that caught them off guard and has affected their defense to instruct the jury not to consider that portion of the testimony.
Your Honor, may I respond? Because I feel like I'm getting gaslit with this clothing thing. That is not the issue about black clothes. It is the fact that she said that she saw a man who matched the description of the shooter with a gun. That's the key issue. It's not his clothing or the fact we know that he was wearing black. And ultimately, I think what the defense, what the prosecution doesn't know about the defense strategy, the court does know. There's things that we could have done and investigations we could have made.
Mr. Goss, I've heard enough. Again, Mr. Attorney, you don't have the benefit of the ex parte brief that Mr. Goss filed, and I think you'll probably gleaned issues from the arguments, but there's no doubt that this was critical to the strategy. And I don't think I have any choice, having denied the mistrial, other than to craft a remedy that will protect the due process rights and hopefully avoid any appellate review that would result in this case being reversed. So I am reluctantly going to instruct the jury to disregard her testimony in its entirety when they come back out. If we could bring her back in momentarily, the witness. Ma'am, could you come up to the bench here very quickly? We're going to let you go here in a minute. I hate to talk to people from the bench. You don't have to sit down. Just right here. I just want to tell you, you may hear later on that I will instruct the jury to disregard your testimony, but I want to emphasize to you, you did absolutely nothing wrong. It is not on you. And I want to tell you just from personal experience, memories of traumatic events change, are different, or you recall more or less. I had a personal experience many years ago. My wife and I were hit by a drunk driver, and I spent 2 months in the hospital. Apparently they almost lost me in the emergency room, but revived me. And I remember that event very clearly, that truck coming at us and trying to get out of the way. But every time I think about it, it's a little different. And that's because of stress and trauma. So nothing about this is on you. We appreciate your bravery that day, and we appreciate your testimony and being brave enough to come in here, and you are excused with our thanks. Take care. All right, we're going to take the rest of the recess till the jury comes back out, so I think they got about 5 more minutes or so. We're in recess.